In the midst of Donald Trump's election tampering case, federal judge Tanya Chutkan has dismissed requests from the former president's legal team to postpone the trial. Chutkan ruled that jury selection would proceed, with potential jurors required to complete a preliminary questionnaire on February 9, 2024. This process aims to assess whether any juror holds strong biases against Trump that might hinder their ability to reach an impartial verdict when the trial commences on March 4. Chutkan's decision includes a clear warning: Trump is not allowed to share juror information during his campaign trial. This measure is designed to prevent Trump, who is already under a gag order in the case, from claiming that individual jurors are prejudiced against him. Chutkan emphasized, the parties must ensure that anyone permitted access to sensitive juror information understands that he cannot publicly disclose the information, and no party may provide jurors' identifying information to any other entity, e.g., the defendant's campaign, that is not part of the defense team or government team assisting with jury selection. This ruling follows multiple attempts by Trump's lawyers to delay the trial. In October, his legal team argued for presidential immunity for actions carried out during his presidency. In August, a federal grand jury indicted Trump on 4 counts, including conspiracy to defraud the United States, related to his efforts to overturn the 2020 presidential election results. Department of Justice Special Counsel Jack Smith is leading the prosecution team, which accuses Trump of submitting false elector slates from swing states he lost to the Electoral College. Trump continues to assert his innocence, contending that prosecutors are politically motivated. In a related development, Chutkan issued an order on Wednesday prohibiting Trump's legal team from accessing some classified government evidence. Instead, they will be provided with an unclassified summary substitution for classified information. Trump's lawyers had requested classified documents, prompting concerns that they were attempting to delay the trials until after the 2024 presidential election. In Florida, a judge postponed pre-trial hearings in Trump's upcoming classified documents trial, which his legal team had sought for months. The trial is scheduled to begin on May 20, and Trump aims to postpone it until after the 2024 election, should he be elected president. Given the complex legal issues surrounding classified documents, U.S. District Court Judge Aileen Cannon acknowledged difficulties in adhering to the schedule she initially set in July. She plans to establish a new timeline as soon as possible. Trump's legal team has been embroiled in disputes over the disclosure of classified documents, which are only accessible in secure rooms set up in South Florida, having been taken from Trump's Mar-a-Lago estate. Cannon confirmed in October that Trump's trial would commence on May 20, 2024, in a Trump-leaning county north of where the documents were allegedly stored. Department of Justice Special Counsel Jack Smith had proposed a December 2023 trial date, while Trump's lawyers advocated for a start following the November 2024 election. Throughout these legal proceedings, Trump has consistently denied any wrongdoing and frequently accused the Biden administration of politicizing federal agencies to undermine his 2024 presidential campaign. Currently, Trump is the leading contender for the Republican nomination. In October, a former federal prosecutor, Preet Bharara, suggested that Trump may be seeking to delay his criminal trials to secure exoneration if re-elected president. Bharara outlined 3 potential avenues for Trump to avoid his federal trials: pardoning himself, appointing a favorable attorney general, or asserting federal immunity. He emphasized that the option of a self-pardon would likely be subject to court litigation.